So I want to thank everybody for coming. I'm Ken Cerini, Managing Partner of Cerini Associates. Just by show of hands, I just want to get a feel for who's here in the crowd. How many people here are board members? Good, most of you. How many CEOs or executive directors do we have? A couple of you. Okay, how many CFOs in the room? No? How many spies from other accounting firms who are trying to steal our material? All right, good. So the reason we do this is last year we issued a board guide, which everybody should have in their folder. It's the guide for effective nonprofit board membership. And we did our first seminar last year off that, and it was a big success. And part of what we feel our job is in serving the nonprofit sector, we work with over 200 nonprofit organizations. But part of what we feel our job is serving the nonprofit sector is to educate. And so this is kind of part of that education process. In June, we also do a training for the nonprofit sector on nonprofit accounting issues and everything else. So, you know, we'll get everybody on that mailing list too. And if you guys want to come to that, that's great too. We have a great program today. We have David Goldstein from Certilman, who's going to be giving you a legal update. We got my partner, Matt Burke, in the back, who's going to be talking about the 990, which is the document that most people look at. And then I'm coming along to wrap things up, and I'll talk about board effectiveness and some of the issues in terms of, you know, some tricks and stuff to get boards more engaged. One other thing I want to talk about, I guess, before we even get started is the Imagine Awards are coming up in May of next year. And I know that sounds like it's far away, but the application process is due by Monday. So what the Imagine Awards is, because I see a couple of perplexed faces, is it's an award program for the nonprofit sector. There's an applicate or information about it within the folder, but there are 5 categories that organizations can apply for, and they could win a $5,000 grant in each of those categories, and you can apply for more than one category. You don't have to just stop at one. We have social impact, which is for large organizations over $2 million. We have Rising Star, which is social impact light, so that's for small organizations under $2 million. We have leadership for an effective leader within the organization, whether it be the CEO, a board member, a volunteer, it doesn't matter. Innovation, if you guys are doing anything cool and innovative, no matter what that project is, put in an application for it. And then we have a separate category for arts and culture. And again, the reason for the Imagine Awards is threefold. First, it's to provide recognition to the nonprofit sector, a sector that does so much for everybody, but never gets the recognition it deserves. Second is for collaboration. The night of the Imagine Awards, we have over 400 people in the room, and we've seen some really good connections happening at the Imagine Awards. And then finally, it's education, which I said before, that's a keystone of who we are as an organization. So, you know, get the applications in. There, go ahead. The application is due Monday. It's been out there for about 2 months now, but it's due Monday. It's not a long application, shouldn't take more than a half an hour to do. And I'll give everybody in this room and everybody who's listening on webinar and anybody who cares in the Long Island, we don't have a whole lot of applications in this year. We normally, last year we had about 170 something applications. So far we only have about 50. So there are 5 categories, there'll be 5 winners, and we have only 50 applications in so far. So we expect by the time Monday rolls around, we'll probably have close to 100 because everybody waits to the last minute. That's what we all do. Our projects expand to the allotted time that we have. But get your applications in because, again, better chance this year of winning than there has been in the past because of the small number of applicants. So everybody get ready to get started. We're going to bring David up here. David's going to do his presentation again about things that are happening from a legal perspective in the nonprofit sector. So, David?
Good morning, everyone. Okay, so we're going to talk about some of the changes in particular that went into effect in late May of this year, amendments to the not-for-profit corporation law. And what I want to do is give you a little background and a little context, and I think that'll also help you not only to understand the amendments and the process that led to them, but also to help you understand some of your compliance obligations going forward under the not-for-profit corporation law. So the primary impetus to the amendments that went into effect in May were some of the unintended consequences of the Nonprofit Revitalization Act of 2013. That act, which went into effect on July 1st, 2014, was the most far-reaching amendment to the not-for-profit corporation law in the 40 years or so since the law was first passed. And in some respects, that extensive amendment went a little too far. And there was actually a very healthy process where a number of the legal groups in the nonprofit sector came together in coalition, and that involved the State Bar Association, which has a committee on nonprofit corporation law. I'm actually the current chair of that committee, together with the City Bar, the Nonprofit Coordinating Committee based in New York City, and Lawyers Alliance, as well as the Law Revision Committee, came together and approached the Attorney General and said, while a lot of the changes to the law were healthy and are workable, a number of them are completely unworkable on a practical level, and we're going to get into some of that. So the process, actually, the legislative process worked. We approached the Attorney General. The Attorney General agreed with us that some of these things needed to be fixed, and together we went to the legislature, and in short order, the legislature adopted these changes. So let's talk a little about the area where most of the changes occurred, the May 2017 changes, and that's in the area of conflict of interest policies. So you may know that prior to the effective date of the Revitalization Act in 2014, nonprofits in New York were not even required to have a conflict of interest policy. And that changed pretty quickly and drastically. As of 7/1/14, every New York nonprofit has to have a conflict of interest policy, but not just any conflict of interest policy. In fact, the sample conflict of interest policy that the IRS itself puts out, that was developed by IRS lawyers, is absolutely inadequate and deficient under New York law, and is a per se violation of the not-for-profit corporation law, because it doesn't have a lot of the demanding procedures and requirements that the not-for-profit corporation law has. So many nonprofits are still using some variation of that IRS policy, and in New York, that absolutely doesn't work. What you have to have in New York is a policy that has all of the procedural and definitional aspects that exist under the not-for-profit corporation law. We're going to get into that, and we're going to get into why some of that had to be tweaked and what some of those tweaks were. So, what the NPRA, the Nonprofit Revitalization Act, did is it, in the area of conflicts of interest, is it mandated what had previously only been best practices.
So the question is, do the changes to the nonprofit corporation law also apply to New York State education corporations who have a 501c3 status?
Yes, absolutely. Not only that, in this area, which is actually a very often a big surprise to many board members, these changes not only apply to education corporations, they apply to religious corporations as well. So all of these conflict of interest and related party transaction provisions that we're going to be talking about are applicable to education and religious corporations. A good question. So we've now mandated what previously were only best practices, and the law, which is 715A of the Not-for-Profit Corporation Law, mandates that the board of every corporation has to adopt and oversee the implementation of and compliance with a conflict of interest policy that applies to directors, officers, and key persons is a definition we're going to get into, and that ensures that those persons act in the corporation's best interest and comply with applicable legal requirements. So let's unpack that in terms of what some of the requirements are for conflicts of interest policies. On a fundamental level, the policy has to have a definition of what constitutes a conflict of interest. This is all mandated point by point by the statute. There have to be procedures for disclosing a conflict or possible conflict to the board or a committee, and procedures to determine whether a conflict exists, and a requirement that the person with the conflict not be present or participate in the board or committee deliberation or vote on the matter giving rise to the conflict. So far, pretty straightforward and pretty rational and intuitive. Next. The conflict of interest policy is required to have a prohibition against any attempt by the person with the conflict to improperly influence the deliberation or voting. Also pretty rational and straightforward. The existence and resolution of the conflict have to be documented in corporate records, including minutes. And minutes are critically important. It's something to note that you can do everything right, but if it's not recorded properly in the minutes, 2 years from now, if someone challenges the procedures or the actions of the board, the fact that you did it right isn't going to help you because there's no record of it. So minutes are critically important in this area. Another aspect that's required under the statute is that prior to the initial election of any director, and that's a little counterintuitive because you wouldn't think that a director needs to fill out a conflict of interest questionnaire before they're elected, but that's what the law requires prior to initial election and at least annually thereafter. And of course, during the course of the year, if any conflict arises, every director has to sign a written conflict of interest disclosure statement. So now we're going to get to an aspect that has caused lots of practical problems for nonprofits. And again, we're going to see how this resulted in some adjustments to the statute. There's a concept under New York law of a related party transaction. And that's actually a type of conflict of interest. Basically, there are two types. One is a garden variety conflict of interest. And a good example of that might be if I'm on the board of a nonprofit, my wife is on the board of another nonprofit, and the two organizations have some sort of relationship. So there's a conflict there for me in terms of my voting, because is my allegiance to my wife and her nonprofit, or is it to the nonprofit that I'm sitting on the board of? So I may have a divided allegiance in that situation. But very important to note that there's no financial interest, because no matter what my nonprofit does with my wife's nonprofit, it's an interaction and transaction between the two nonprofits, and neither my wife nor I have a personal financial stake or benefit. On the other hand, in a related party transaction, by definition, we're dealing with a type of conflict where there's a financial interest for the director or officer or key person. And because of that, because there's a financial interest, these types of conflicts, related party transactions, have increased scrutiny and enhanced fiduciary duties under the law that apply to them. And note that there are very detailed definitions in the law that around all of these concepts, around related party transactions and who they apply to, and again, we're going to touch on that. So what is a related party transaction? And let's look at the pre-May 27th amendment definition, and we'll see why it had to be fixed and what the fixes are. So as of the pre-May 27th amendment, a related party transaction is any transaction, agreement, or any other arrangement in which a related party has a financial interest and in which the corporation or any affiliate of the corporation is a participant. And we'll look at some of the unintended consequences of that broad definition. A related party is an officer, director, or key person, a relative of any of those, and relative is an incredibly detailed and broad definition, and there's a wide net under the statute. For instance, a relative extends all the way to the great-grandchildren of a director, and even the spouses and domestic partners of a director's great-grandchildren. So it's a huge net that's cast out in terms of relative. And so in addition to a director, officer, key person, any relative of any of those, it's also any entity in which any of those persons has a specified level of financial interest. Okay, so once you've got a related party transaction, what are the enhanced fiduciary duties that are going to apply? What are the procedures that are going to apply? First, and most obviously, a director, officer, or key person who has an interest in a related party transaction has a duty to disclose in good faith to the board all of the material facts concerning such interest. That's sort of at the most basic level. The conflict of interest and related party provisions require full disclosure. Next, and this is where we start getting a little bit into the weeds of some of these provisions. No corporation, and this is pretty much a quote from the statute, no corporation shall enter into a related party transaction unless the transaction is determined by the board or an authorized committee to be fair, reasonable, and in the corporation's best interest at the time of the determination. So think about what we have here. We've got a situation where it's not enough for the board to receive disclosure, look at a transaction, and approve it. That's not enough. The board literally has to utter magic words, and those magic words have substantive significance, and the formula is that the board has looked at the transaction and determined that it's fair and reasonable and in the corporation's best interest. And part of the reason for that is that the legislature wants the board to understand that here we've got a financial transaction where an insider is benefiting, and we want you to affirmatively consider and make a statement that you've looked at this transaction and that it's fair, reasonable, and in the corporation's best interest, and we want that determination in the record. And of course, no related party can participate in deliberations or voting relating to a related party transaction. Question from Ken?
Yeah, just a quick question. If a board makes that determination at the time the contract is signed and that relationship lasts the next year, the year after that, do they need to reaffirm every year, or once they do it once, that's enough?
So that's a good question. It's not specifically addressed in the statute, but it's best practice to look at that transaction pretty much on an annual basis and make that determination again and again. What's going to lead us to that conclusion is the sensitivity that the legislature and the Attorney General have to these kinds of insider financial transactions. So if we've got a charitable nonprofit, and a lot of you are on boards of charitable nonprofits, there are two types of nonprofits under the law, by the way. Non-charitable nonprofits, examples of those might be trade associations, homeowners associations, country clubs, and charitable nonprofits, which is most of the nonprofits, and I would assume that most of the board members here are on the boards of charitable nonprofits. So with respect to a charitable nonprofit, if a related party has a substantial financial interest, and of course, it would be too easy if substantial financial interest was defined. It's not defined, and it was intentionally left undefined under the statute. So if a related party has a substantial financial interest, there are further procedures that apply, and most significantly, prior to entering into the transaction, the board needs to consider alternative transactions to the extent available. And in addition, the transaction has to be approved by not less than the majority of the directors or committee members present at the meeting. And that's trickier than it sounds, because the person or persons who leave the meeting because they're related parties count in calculating what the quorum is and what the majority is. So that can be a little tricky. And in addition, the board needs to contemporaneously document in writing the basis for the approval of the transaction, including the consideration of alternative transactions, and that's plural. So it's not enough to consider one alternative transaction. You need to consider at least two, and probably best practice to consider three. Okay, so this was the landscape pre-May 27th, 2017. And so what were some of the unintended consequences of the definition of related party transaction? Let's look at one hypothetical. If we've got a large nonprofit And a board member who sits on that nonprofit's board owns an office supply distribution business. That board member, through his or her business, provides supplies to the organization with a market value of $5,000, but only charges $500. That's well below market price and well below cost. Great deal for the nonprofit, right? So of course, we want to make sure that the nonprofit can go forward with that kind of a transaction. Of course, the nonprofit can, but would have to, under the rules in existence before May 27th, go through all of the related party transaction procedures, even though it's an incredibly good deal, and by the way, only $500 is involved. So that's one hypothetical. Okay. Here's another. An auto dealers association, which is a non-charitable trade association, non-charitable nonprofit. Purpose of the association is to conduct trade promotion activities primarily through advertising. So we're the board of an auto dealers association. We want to enter into a contract with a prominent athlete, Yoenis Cespedes on the Mets, or Derek Jeter, a former Yankee, to be our spokesman and representative in a multimedia ad campaign to promote our vehicles and our brand. It's exactly what we're supposed to do as an auto dealers association. There's a little problem there. Who's on our board? Everyone on the board of the Auto Dealers Association is a principal, an owner of one of the auto dealerships. That's what we'd expect. Because they're directors, they're related parties under the law. They each have a financial interest in the transaction, right? Because if we hire Derek Jeter to be our spokesman, we sell more cars. It's going to benefit each of our auto dealerships. So we've wound up in the uncomfortable position of all of us are directors, all of us have a financial interest in the transaction, and because of that, none of us can participate in the decision-making. It's a related party transaction. We're all related parties. We need to leave the room. We can't participate in the decision. So guess what? No one on the board can vote to enter into this contract, which means the organization, which is formed to promote our brand by advertising, can't enter into this kind of arrangement. So that's a problem. And similar issues arose in other non-charitable nonprofits, homeowners associations, country clubs, other clubs, where you had transactions that benefited everyone on the board because they were members, and therefore no one on the board could vote. Similarly, this unintended consequence of the related party transaction rules also rippled into the sphere of charitable nonprofits. So for example, if we were the board of a camp or a school, and if I'm sitting on that board, tuition paid by the camper or the student is a financial transaction between my family, me, and the organization that I'm sitting on the board of. So it's a related party transaction, and again, would be subject to all of these complicated procedures. So we had a situation where, in concept, the changes to the law made sense, but in practice, they were unworkable and unwieldy. So there were a series of amendments that were passed based on this interaction between the coalition of legal groups in the nonprofit sector and the Attorney General that went into effect on May 27th. And basically, they carved out certain types of transactions from the definition of related party transaction. So not-for-profit corporation law section 102(8)24 defines what a related party transaction is, and now it says that a transaction will not be a related party transaction if, number one, the transaction or the related party's financial interest is de minimis. De minimis is Latin for minimal, insignificant. So go back to my first hypothetical, the office supplies, $5,000 worth of office supplies that I, as a board member, that my entity is selling to the nonprofit for $500. That's de minimis. It's an insignificant amount. So thanks to the May 27th amendment, that is no longer a related party transaction, and we don't have to jump through all of the hoops that would be required for a related party transaction. Question from Ken.
Sorry to ask all the questions.
Yeah, please.
When you talk about de minimis, you're talking about the benefit derived as de minimis, or are you talking about the transaction itself as de minimis? So if I have a rental property and I give it to a nonprofit and it's worth $500,000, but I'm giving it for $1, $500,000 might be material, but the dollar is de minimis. So which one is the rule for de minimis?
It's both. It's either the transaction or my financial interest. So either one of them. If they're de minimis, you're out of what a related party transaction is. So a second exclusion from what a related party transaction is. A transaction is not a related party transaction if the transaction would not customarily be reviewed by the board of this organization or similar organizations in the ordinary course of business and is available to others on the same or similar terms. So think about the hypothetical of tuition. I'm the parent of a student in a school or a nonprofit camp. Tuition is something that my tuition transaction wouldn't be looked at by the board as a related party transaction, and it's available to everybody else, not just board members. So it's no longer a related party transaction, and we're spared from having to jump through all of the hoops in the statute. And then the third carve-out is for transactions that constitute a benefit provided to a related party solely as a member of the class of beneficiaries that the corporation intends to benefit as part of the accomplishment of its mission, and that benefit is available to all similarly situated members of the same class on the same terms. A lot of words, but think about that auto dealership situation. What we're supposed to do is advertise our cars. So that's the benefit that's provided as part of the accomplishment of our mission, and it's available to all of the auto dealers on the same terms. So now that type of transaction also is excluded from what a related party transaction is. So those three amendments that went into effect on May 27th created a sea change in the burden on nonprofits because they eliminated these really unwieldy compliance requirements that applied to transactions that really were not suspect and didn't merit that level of governance work for board members and boards. Okay, so some other of the amendments that went into effect on May 27th. There was a concept in the statute that as it was passed in 2013 of a key employee, and that created lots of confusion, primarily because a key employee, notwithstanding the fact that it was denominated using the word employee, the definition was way beyond what an employee was and would encompass people who weren't employees. So for instance, the definition of key employee included not just someone who was employed, but anyone who was in a position to exercise substantial influence over the affairs of the nonprofit, and that could, in certain circumstances, be a donor who's not an employee at all. So, so that definition created lots of confusion and uncertainty, and that definition was changed and eliminated. And so now instead of key employee, we've got the concept of key person. And so the conflict of interest rules apply to directors, officers, and key persons. And a key person is someone who has responsibilities or exercises power or influence similar to a director or officer. So you don't have to be a director or officer. And one of the reasons that this is in the statute, a lot of the provisions relating to conflicts and related party transactions arose from scandals you might have read about over the years in the newspaper. And in particular, this concept of a key person relates to the Pedro Espada scandal. Pedro Espada was a Bronx state senator, and he set up this whole series of nonprofits. He had no formal role with any of them. He had his relatives and cronies running all of these nonprofits, but they were siphoning money to him, notwithstanding the fact that he had no formal role. He was pulling the strings, but was not a director or officer. So the statute specifically contemplates that sort of a problematic structure, and says that even if you're not a director or officer, if you're pulling the strings, you're a key person, and these rules apply to you. Pedro Espada, I believe, is still in jail. He got sent to jail for a while. Okay. So some of the other changes. There's an amendment that clarifies that not only the board itself, but also an authorized committee of the board, very often an audit committee, can approve a related party transaction. And here's a really key change, very important. These rules are so complicated, and it's taking nonprofits a while to ramp up and understand them and be in a position to comply with them. And so very often, nonprofits were discovering that they entered into transactions that were eminently fair for the organization, but they did it without complying with all of these provisions. And so the law introduced, the effective May 27th, there's an ability to retroactively ratify a related party transaction, but only under very limited circumstances. So I'll give you a real life example. A client of mine has a director on the board who owns a catering hall. And every year, he allows the nonprofit to use the catering hall for their annual gala. Probably if the nonprofit had to go out on the market and rent a catering hall, it would cost them $80,000 to $100,000. And I'm guesstimating, but I would think that the cost for the catering hall may be in the range of $30,000. And this director, because he's so dedicated to the nonprofit, gives them the use of the catering hall for $15,000 every year, just to cover some of his costs. Well, even though that transaction is eminently in the interest of the nonprofit, it's not de minimis. So it's not carved out of related party transaction. It's still $15,000. It's a financial transaction with a director, so it's a related party transaction. So what happens if that nonprofit wakes up one day and realizes, whoops, we've been doing this, and we never treated this as a related party transaction, and we didn't go through all of the procedural steps. What the law now allows is retroactive ratification of that transaction, as long as, one, the transaction was fair and reasonable and in the best interest of the corporation when entered into. That works with my transaction. Number two, it's ratified before the Attorney General comes knocking. So if the Attorney General calls up and says, by the way, what's going on with this transaction, or if they send you a letter that they want to talk to you about a particular transaction, it's too late. It's got to be before the Attorney General comes knocking. And then the third prong of what you're required to do is you're required to demonstrate that you've put appropriate compliance procedures in place so that you can't have this kind of related party transaction without the proper approvals going forward. So if you can comply with those provisions, you're able to retroactively ratify a related party transaction that wasn't properly approved in the first place. Okay. Another change, question? Good, okay. Another change that went into effect on May 27th relates to independent directors. Both the provisions defining what it is to be an independent director, and that focuses on financial relationships between the director's family, and any entities that those persons either control or work for. Those provisions were somewhat relaxed, number one, and number two, the requirement that only independent directors could make determinations with respect to conflict of interest and whistleblower issues was changed to a much more manageable provision that says if we've got a conflict of interest, you don't need to be an independent director to be able to vote on it. As long as you're disinterested, you can vote on it. And that alleviated a situation where nonprofits were finding that they couldn't meet quorum requirements because directors were disqualified because they weren't independent. So now there's a more manageable standard, and it kind of makes sense, right? If I'm on a board, I can vote on a transaction involving a conflict or related party transaction as long as I don't have an interest in that particular transaction. So another area that the May amendments affected was the area of committees. And committees is a really technical area. under the not-for-profit corporation law, and most nonprofits don't realize the level of technical complexity involving committees. So first of all, there are two types of committees under the law. One type is a board committee, and that committee can only have voting members who are sitting board members. That's a board committee, and that committee has to have a minimum of 3 board members on it. And so any board committee, exclusively voting members who are directors, number one, and a minimum of 3 board members sitting on each committee. And such a committee, a board committee, can be delegated with a slice of board authority. The other type of committee is called a committee of the corporation, and the nomenclature is a little confusing and hard to understand, but bottom line is a committee of the corporation can have non-board members on it, but the corollary to that is that those non-board members on a committee of the corporation cannot have any board authority. So what the statute did is it made it easier to form board committees, because previously there was a supermajority requirement. You had to have a high threshold approving a board committee to form it or to populate it with board members. And now it's just a regular board vote. So if a majority of the board can make a decision on any matter, that would also apply to forming a board committee. The only exception is an executive committee or a similar committee that has very broad board authority, and that kind of committee still requires a higher supermajority threshold to establish. The other really important change, and this is one that's very much overlooked, when our coalition was looking at some of the aspects of the not-for-profit corporation law that we wanted to work with the Attorney General and the legislature to change, we looked at committees, and almost accidentally we found a provision in the law that had been there all along and no one had really focused on, and really a counterintuitive and very problematic provision. And that provision said that a non-board member serving on a committee of the corporation had the same duties and liability as an officer of the corporation. So if I'm a volunteer, I'm not on the board, I'm asked to serve on a committee of the corporation, which is essentially an advisory committee, no authority. All we do is give advice, give input, consult with the board on a specific issue. That volunteer, under the statute as it existed before May 27th, had the same duties as an officer and therefore the same potential liability for breach of duty. And that made no sense. So when we presented that to the Attorney General agreed that that was something that should be changed. And together with the coalition, those changes were proposed to the legislature, and that provision has now been eliminated from the law. So a non-board member now does not have liability for serving, does not have duties or liability for serving on an advisory committee. So it's really important to remember with all these changes. So the law's changed a lot in the last few years. There were the massive changes in 2014, and there have been a series of changes since, up to and including this last bunch of changes in May. It's really important for every nonprofit to make sure that your bylaws and your conflict of interest policy are updated appropriately to reflect these changes. Some of these changes are mandatory. So, for instance, we talked about the definition of a key person. That's a mandatory provision, so your conflict of interest policy needs to incorporate that and say that it covers directors, officers, and key persons. There are lots of other provisions that aren't mandatory but are hugely beneficial to nonprofits. So, for instance, all those exceptions, those carve-outs, exclusions from what a related party transaction is, many conflicts of interest policies don't have them because they were drafted before May. And so they have the original overbroad definition of a related party transaction. And if you don't adjust your conflict of interest policy, that's what you're stuck with, and you don't have the benefit of these new exclusions. So that's one area to look at. And bylaws, what I very often see is that even some of the amendments from 2014 that are incredibly favorable to nonprofits are not reflected in bylaws. And a perfect example is prior to 2014, email notice and email unanimous consents by the board to approve transactions were not permitted under New York law. But on July 1st, 2014, you could use email for those things. A lot of nonprofits have not adapted their bylaws to include that. So even though the law allows you to use email, and many nonprofits are doing it, they're doing it in violation of their bylaws, and so their use of email is essentially invalid. So these are really easy fixes and very important to make, and the only way to do it is by updating your bylaws and your conflicts of interest policy. So questions before I, yep?
In a situation where there is a committee chair who owns, he's the chair of the Plant and Facilities Committee, where he's responsible for overseeing capital improvements to the property of this nonprofit. And this committee chair is also owns a general contracting company in the construction industry. Could you tell me if he solicits proposals for new work from his vendors? Can he solicit proposals from his vendors? And B, if one of his vendors is selected to do the improvement, would that be a conflict of interest related to the change in the art-related party transaction? Okay.
Good question. And in fact, those are the kinds of things that it's really important to keep your eye on. Let's kind of peel back all of the definitions and go back to the concept, right? What's a conflict of interest? It's a situation where you may have some sort of divided loyalty, where you don't have an undivided allegiance to the corporation. And that's a perfect example of a situation where someone could have an undivided loyalty. Could have a divided loyalty. So absolutely a conflict of interest, for sure, and something that should be treated, it should be fully disclosed, and should be, whatever transactions are entered into have to be very carefully vetted and scrutinized under all of these rules. So yes, absolutely a conflict, possibly a related party transaction as well. And either way, it needs to be vetted following all of the procedures in the statute. Okay. Okay. So
thank you.
Sure, of course. So.
Excuse me, you mentioned earlier the supermajority that is needed for certain executive committees. What is the definition of supermajority?
So it varies a little bit depending on the size of your board. It's a majority of the entire board for boards of less than 30. If you have 30 or more, it's slightly adjusted. I believe it's 3/4 of the directors who are voting, assuming that there's a quorum present. So that's something to look at very carefully in terms of where you fit. But important to know that an executive committee is the one committee that does have that sort of a supermajority threshold, and that's kind of again a logical distinction, because the executive committee generally has way more authority than any other committee. So it makes sense that we're going to have a higher threshold to establish it or vote someone onto it. Yes.
Why don't you get some exercise? I think I have a relatively simple question with regard to non-board members serving on a board committee. What if we establish a development committee of a particular organization that has 3 members on it, and then we ask some people from the private sector to help us with that development committee, but they're not getting any compensation and they wouldn't be involved in any kind of fiduciary way with regard to the organization or what we might go forward with. There's what you said with regard to those people not being liable. Am I interpreting that correctly, that they wouldn't be liable?
Well, so a couple of things there. So what you're describing is a board committee that has a minimum 3 directors on it, but also has non-board members as advisors.
Correct.
And that's perfectly acceptable and a very common practice. It takes a little discipline, though, because over time, committees like that, when they vote, very often it's the advisor or the advisors who've been brought onto the committee who have particular expertise, who everybody actually looks to in terms of an informal leadership role when decisions are made. So it's a little counterintuitive that at those moments, those persons don't have a vote. They really don't have a voice in that sense. So that discipline is really important. And sometimes what I see in minutes when I look at committees like that, forensically, all of a sudden that over time, those kinds of people are voting, and that invalidates the whole decision-making process. So you can do it. And most nonprofits do. It's a very common practice, but really important to keep your eye on the ball and where the dividing line is, and for everyone on the committee to know who can vote and who can't.
Okay. So it comes down to who votes and who can't with regard to that kind of a situation.
Right. And non-board members now, thanks to that change, don't have the duties and the liability that board members have. Answering your other question.
Thank you.
Okay, sure. So on the subject of, I want to talk a little, and this really underlies all of nonprofit law in New York State. I want to talk a little about the fiduciary duties of directors. And there's a lot of, by the way, you've got a book of materials from me that's blue and white with a spiral binder. And it has, in addition to my PowerPoint, it has some materials on the laws that we were talking about and the amendments that we were talking about that were effective May 27th. And it also has some materials actually lots of materials on the duties of nonprofit directors. And that really is the linchpin of New York nonprofit law, because at the end of the day, board members have legal duties that they're responsible for, and the uncomfortable truth is that they also can have personal liability for breaching those duties. So what are those 3 fundamental duties? Those are the duty of care, the duty of loyalty, and the duty of obedience. And for any, as you know, when Ken asked how many of you were sitting on boards, and it was a decent percentage of you, you need to be cognizant of these duties at all times. Number 1, because that's your responsibility. And number 2, and you can rank these however you want, if you breach those duties, you have personal responsibility and personal liability for breaching those duties. So first, the duty of care. And it is what it sounds like. And you have this in your materials, and you actually have a bunch of interpretive things on this as well, which I'll point out in a minute. A director has to discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in like position would exercise under similar circumstances. So bottom line is you've got to be careful the way a person would if they were acting prudently in your circumstance. And basically what this is the director's oversight function, the board's oversight function. But when you think about it, you can't exercise that oversight function without participating in the organization's governance on a regular basis and being familiar with what the organization's doing, being familiar with its finances. So bottom line is, if I give my name, if I'm a prominent person and I give my name to an organization to be on their board so that I can be listed on their letterhead, great for the nonprofit. But I've got the same legal duties and responsibility as a director who goes to every meeting, even though I've never been to one. So that's not a good practice. Allowing your name to be used as a board member, because in fact you've got all of these oversight duties, and by definition you can't possibly comply with them if you don't go to the meetings and participate in governance. So the duty of care is fundamental to what a nonprofit director has to do. And how do we understand what that responsibility entails? And I wanted to give you some resources here and something of a roadmap. And one of my favorite resources for nonprofit directors is a publication, and you have it. I believe it's tab 2 in your little book from me. It's called Right from the Start, and it's subtitled "The Responsibilities of Directors of Not-for-Profit Corporations," and it's published by the Attorney General's Charities Bureau. And this document is written for non-lawyers and non-accountants. It's written so that people can understand, and it's a wonderful tool because it really lays out what your duties are and ways that you as a director can comply with those duties. And remember the second piece of that: when you're complying with those duties, you're protecting yourself from exposure to personal liability. So if you do nothing else, you should, over the holiday, if you haven't read it yet, read Right from the Start. It's about 8 or 9 pages long, and every board that I represent, it's something that I give to them, and I insist that they read. Another really useful roadmap to what a director's duties are in New York State is a decision by the Board of Regents from 1997 in the Adelphi University matter. And this was a situation where the board was not at all complying with its fiduciary duties, and members of the board were actually held personally liable as a result of that. And this is not in your materials. It's a very lengthy decision, and if you'd like a copy of it, reach out to me and I'll get it for you. It's kind of hard to find, but again, it provides a wonderful roadmap for a director as to how you can comply with your responsibilities under the law. And the duty of care, we see it in terms of setting up appropriate internal controls and policies and procedures for the nonprofit, and in particular, the role of the audit committee. And if you don't have an audit committee, the entire board in audit oversight is a very important component of the duty of care. Duty of loyalty, we've spoken about that a lot, and not directly, but conflicts of interest and related party transactions are all about the duty of loyalty and complying with the duty of loyalty. So the last of the 3 duties that I want to talk about is the duty of obedience, and this is the least understood and least well known of the 3 nonprofit primary legal duties, and the reason is that the other 2 duties, the duty of care and the duty of loyalty, are duties that a for-profit director in a business corporation would have. The duty of obedience is unique to the nonprofit corporation world. And so what is the duty of obedience? It has a couple of components. Number 1, you have to comply with, translate, obey all the laws and regulations that apply to the nonprofit. That's a lot more difficult than it sounds. So you've got a taste of how complicated some of those laws and regulations are. There are federal laws, there are state laws, there are local level laws. So that's a lot to keep track of and to comply with, but that is your duty under the duty of obedience. And in addition to that, the duty of obedience requires that a nonprofit follow its internal governance documents and policies, and you as a director are responsible for making sure that that happens. And that can be a little challenging because very often your governance documents don't follow the law. So a very typical example of that is bylaws. Bylaws can be changed by the board without submitting them to any regulator for review, even without submitting them to your lawyer for review. Not a good idea. But so I very often see in bylaws very rational provisions that are completely inconsistent with what the law allows. So I had a board that had 50 members on the board, national nonprofit, so it had a very large board, 50 board members all around the country, and they put in a rational provision that said the board can act without a meeting by the written consent of 45 of the 50. that makes perfect sense, very rational, completely inconsistent with the law, and any decision following that was invalid. So the director then has sort of an interesting quandary, right? Because the duty of obedience requires you to follow the law, but also to follow your internal governance documents. So part of that then is sorting out where your internal governance documents are inconsistent with the law and fixing that. So the duty of obedience is quite a complicated aspect of nonprofit law, and something, again, for all of you who are directors to keep your eyes on. The last thing that I want to share with you as I'm getting my 2-minute warning is if everybody could take a minute, I really encourage you to go through the binder. There's lots of, I think, really useful and helpful documents in here. At the end, there are a few articles that I've written that are, again, probably the last 3 tabs that are, again, like the Attorney General publication, written for non-lawyers. So they should be helpful guides to some of the aspects of nonprofit law that we've spoken about and some that we haven't. But I want you to take a minute to look at tab 3. For those of you who are board members, the intent is not to scare you, but to kind of have you adequately forewarned. So tab 3 in your binder. Here's your binder. Tab 3 is a summons with notice. And if you look at the first page, it says to the defendants, and it lists a whole bunch of people, 1, 2, 3, 4, 5, and then going on to the next page, 6, 7, 8, actually 7. Those 7 individuals are the board of this nonprofit. And this is an instance where this is a Queens-based nonprofit a couple of years ago, and about a year and a half ago, all of the directors were sued, and they were sued personally, okay? And if you look at page 2, the bottom paragraph on page 2, what were they sued for? It says, please take notice that this is an action to hold accountable the directors of the organization who, in violation of New York not-for-profit laws, section 717 and 720, 717 is the duty of care that we talked about, and other applicable law, have neglected, failed to perform, and or violated their duties, including but not limited to their duty to act in good faith and with the care of an ordinarily prudent person in like position would exercise in similar circumstances, again, the duty of care, in the management of the organization by permitting $750,000 to be stolen by 3 former employees, by hiring non-independent auditors, negligently hiring employees, and otherwise breaching their duties to the organization. So this doesn't happen every day, but this is just an instance to kind of to show you how easy it is for directors to wind up in the crosshairs for breach of duty. So with that, I turn it back over to Ken. I thank everyone for their attention, and I wish everyone a wonderful Thanksgiving.
Thanks, David. Up next, Matt Burke, talk a little bit about the 990.
Good morning, everybody. As Ken said, I am Matthew Burke. I am his partner with Cerini Associates. I am someone that focuses probably 3/4 of my time on the nonprofit sector. So I'll be walking you through the Irs Form 990 and all sorts of different implications that come along with it. In front of you, there's a brochure with our logo on it. And in there is a whole bunch of paraphernalia, but behind that is an actual copy of the Form 990. I will be walking through the form, so it may make sense for you guys to have that in front of you as I speak. This way you know what I'm talking about, what I'm referring to. So I'll give you a few seconds to find your place there. It's the one that looks like a big giant tax return. Everybody good? Yes, I'll assume so. Okay, so first, Ken gave you a little bit of a shameless plug. I'll expand on it a bit. So we're Cerini Associates. We're a full-service accounting firm located in Bohemia, about a mile from the Islip MacArthur Airport. We're a firm of nearly 50 people now, 4 partners, and as I said, and as Ken said, and as is pretty apparent just from us being here talking to you all in a nonprofit sense, we focus on nonprofit. We have over 200 nonprofit clients. We handle nonprofits of all shapes and sizes and locations. Really, from the startup phase, we file a lot of applications with the IRS in New York State to get nonprofit, to get tax exempt status for a bunch of nonprofits, and we handle the life cycle always, all the way up through $100 million budget corporations. And it's worth noting we're one of the top 10 firms in the New York metro area. If you look at GuideStar and see who prepares 990s and tax returns, we're in the top 10, even though we're only 50 people. We focus so heavily on the nonprofit sector that we have as many people focusing on that sector as much larger competitors. So why am I here talking to you about the IRS Form 990? Is everyone pretty much familiar that this at least is a thing, that it exists, that it's something that you have to file every year? So, well, what is it? It's an annual reporting return that certain tax-exempt organizations must file with the IRS. Provides information on the organization's mission, certain governance factors, its programs, and its finances. So this is the document that's publicly available. It's on all sorts of different websites out there. It's out there for public consumption. So you want to make sure a few things. One, that everything in there is accurate. Two, that it's telling the right story that you want it to tell, because it is consumed by all sorts of different eyeballs. And really that it's just representative of what your organization is. Don't look at it so much as a tax return as it is an information return, as a vehicle to really promote your organization, because so many people look at it. It's worth noting that no significant changes have taken place and have affected the 990 in the past several years. Going back maybe 7 or 8 years, the IRS did a complete retool and reconfiguration of the 990, and that got it to its present form with a whole bunch of supplementary schedules, a whole bunch of annoying questions, governance questions that weren't there previously. Really not much has changed all that substantively over the past few years. And realistically, looking at the way the IRS's budgets have been a little bit decimated, and knowing that there's changes in tax law that are coming down the pike that affect for-profits, individuals, trusts, and estates, chances are there won't be any significant changes to the IRS 990 in the future going forward, except that it may modify slightly to conform with accounting regulations that change. So I'll be bouncing back and forth between the IRS and tax and accounting. They don't, of course, speak the same language, because that would just make it too easy for everybody. So who reads the 990? Donors, potential donors, government grantors, private foundations, watchdog agencies, that's the GuideStars, the Charity Navigators of the world, the press. We just went through an election cycle where both candidates had some smear on them because they ran foundations in some way, shape, or form that apparently didn't do the right thing. And it was all over the media for many months. You, of course, don't want to be in the papers for anything like that. It's posted on various websites. I mentioned earlier, GuideStar is the most well-known. Charity Navigator is becoming even more well-known. The State Charities Bureau website itself has the 990 on there. It also, you may be surprised to hear, has your articles of incorporation, your original 1023 application, which is the application you sent to the IRS to get tax-exempt status. It has your audited financial statements, or your reviewed financial statements, if you're required to file them. That's all aggregated in the Attorney General's website on the state form. A lot of people don't realize that that's out there. Whenever we bid on a new client, that's the first place we go, because we can dig a little deeper than we can if we just go to GuideStar or Charity Navigator. We're seeing these Charity Navigator ratings really affect and influence donors and really have an impact on organizations. Again, to give it some perspective, we have clients that want us to modify, and I don't want to say manipulate, but manipulate the 990 to maximize their Charity Navigator ratings, because so many people are looking at it. So if you're not aware of what this is, it's just a website, Google it, and take a look and see how your organization stacks up, how it fares, what its numerical scores are, because it's important. It's something that's really getting out there more and more. People are becoming aware of it. And as the younger generations of donors are out there, what are they doing? They're going online to research you. And they're crafty. They know where to look, and they'll find out whatever it is they need to find out. And if a competing agency is a 5 and you're a 3, who's getting the dollars? The 5. So if you need help cracking the codes, because they are algorithmic, if that's a word, in form, there's some numerical financial considerations. There's some questions on the 990 that influence the score, but we figured it out. We actually have a website, an article on our website that you could look at and give you some guidance as to how to appropriately maximize your score on these different ratings agencies. So what's the point of the 990? You don't really pay tax. You're a tax-exempt organization. Why file? Why does it even matter? Well, the IRS realizes, and the states, that you're stewards of public money, you're stewards of donor money, and really the 990 exists for the purposes of protecting those investors, those stakeholders that are giving money to your organization. So it's the IRS's way of implicitly, in a lot of ways, because they don't tend to audit too much in this area, but really implicitly hold you accountable to the donors, to the boards, to everyone else that you deal with on a day-to-day basis. It's really meant to show a realistic picture of your organization, what it does, how it operates, how it's governed, and it gets really into some nitty-gritty questions that we'll go about later. Promoting tax compliance, protecting the donations. The IRS likes to act like their forms are easy to fill out, but if they were, I wouldn't have a job. Ken wouldn't either. But realistically, they do have some simplified methods of reporting. So if you're a very small nonprofit, tax-exempt entity, if you have $50,000 or less in revenue, you can literally go on their website, click a box and say, I have under $50,000 in average revenue the past 3 years. Take this and leave me alone. I don't want to file this 50-page form that's going to take me hours of time and $1,000 to pay an accountant to do it. There's also a 990EZ. It's a simplified filing. It's not quite as checkboxy as the 990N, but it's maybe 6 or 7 pages instead of a lot more than that with a full 990. And that's if your charity raises between $50,000 and $200,000 in revenue and has less than $500,000 in assets. So obviously, if you have more than either of those, you're required to file the full, complete 990. In general, though, who is subject to this filing? Oh, sorry.
Quick question from a federal perspective, but from a New York State perspective and the Char 500, is the New York State's requirements a little bit, are they more stringent than from a federal perspective, to the point where from a federal, you might be okay with the postcard, but from a state perspective, you'd still be required to provide more information? Or you might be better off just doing a 990 anyway because of the state's requirements? It's
a good question. The state has similar and different requirements at the same time. First, the state's form, as you said, the CHAR, C-H-A-R 500. It's really an attachment that goes with the full 990, and it gets mailed off to the state, along with either a reviewed financial statement or an audited financial statement if you're over certain thresholds in revenue. So the state does impose stricter regulations on you there. What we see a lot of organizations do, if they are 990N filers, they may opt to file the 990EZ because it just gets that document out there in front of the public and becomes a sales pitch for you. Whereas a 990N, if you look up on GuideStar or on the Charities Bureau, you'll just see that essentially nothing.
The threshold for New York State for the 990 N is 25,000. So you have 50,000 at the federal level, but at the state level, at $25,000 or more, you actually have to file a 990EZ or attach a 990EZ anyway.
Which you wouldn't necessarily have to file with the IRS, but we see. Honestly, the EZ is not a big deal. It's a fairly simple form. It's something that if you're running a small nonprofit, you theoretically could complete yourself without involving expensive professionals like myself. It's just not as simple as checking a box for the 990N. So organizations exempt from income tax under Section 501A of the Internal Revenue Code, certain political organizations and other non-exempt charitable trusts are subject to 990 filings. Realistically, what does that all mean? A lot of words there. Well, first I want to explain that nonprofit and tax exempt are not synonymous. They're not necessarily the same thing. You can file with David Goldstein with the nonprofit corporation law of New York State and become a nonprofit, but you're not yet tax exempt. A lot of people assume that if I'm a nonprofit, I file a 990, I'm tax exempt, I don't have to worry about taxes. Untrue. You have to petition the IRS and then the state and say, hey, IRS and state, I'm a nonprofit. Here's what I plan on doing with my charitable status, my tax exempt status, should I get it. This is what my board is going to look like. This is what my budget will be for the next 3 years, and a whole bunch of other documentation and questions. The IRS usually approves that in a couple of months. Then you become a tax exempt entity. But if you're just a nonprofit and you're operating as a nonprofit without that tax exempt status, technically shouldn't be filing a 990. Tax exempt, tax exempt and charity are not the same thing either. You can be a tax exempt entity that's not a charity. Charity is typically a 501c3, but as David mentioned earlier, there's all sorts of different exemptions in Internal Revenue Code section 501c. So 3 is for charities, but there's 28 others. There's 6 for trade associations like a chamber of commerce or something like that. 7 for social clubs if you're country club. If you're a cemetery, you'd be a 13. There's a whole slew of tax exempt. As again, David mentioned earlier, you're probably mostly charities here, if I'm not mistaken. Is there a question? No? Okay. So key points here for startup type nonprofits, just know that you're not done once you incorporate. You have to file with the IRS to become tax exempt, and then you would trigger that 990 filing requirement. So now is where we really talk about and walk through some aspects of the form itself. So if you have that you're ready, that should be helpful. Part one is a general overview and summary of pertinent information generated from various parts. So it pulls in and gives you an opportunity to write about the organization's mission. It summarizes the number of board members, volunteers, and number of employees that you had during the past year. Gives an overview, a summary of 5 or 6 revenue items aggregated. Shows your total revenue. Then shows a total of your assets, your total liabilities, your total net assets for this year and the prior year. It's meant to give a quick snapshot for someone that doesn't want to pour through the 20 to 50. The thing can really expand and be a very large document, pages. You can just focus on that page one, get a sense of the organization, and then move on if you'd like to. But if you don't want to move on, you can dive much deeper in and read all about the organization and what it does. Section 2, Part 2 is just a signature area, so we're skipping that. Part 3 is the Statement of Program Service Accomplishments, which requires reporting regarding your program service accomplishments. It's what you do. What's your different programs that were run and operated during the course of the year? What did you achieve? This is where you have the opportunity to really write whatever you want. And you could put pages in here. I wouldn't advise that. It becomes a little bit too much for the reader, but we have too many clients that just put one sentence. We have an education program. We have a developmentally disabled children program. Expand on it. Really tell your story here. What do you actually do? What are the drill down? What did you accomplish during the year? How many people did you serve? And really focus on these different factors, because that's really where the world is going anyway.
If I can just make a comment. How many of you, just a question I should say, how many of you actually have your development people or program people help write that section, part 3 of the 990? I got 2 hands up. That's something you should really be not relying upon your accountants to fill out. That's the section of the 990 that really you should have your program people and or development people working on, because again, this is the form that everybody looks at. This is a section that people go to get a deeper understanding of what your organization does. And in here, you should be talking about your program service accomplishments. You should be talking about impact that you're having. So this is a really important section for you from a marketing perspective.
Just a quick question, if you don't mind. I recall that there's an obligation that if someone calls your offices or stops by your offices, that you're obligated to provide them with a copy of the 990. Is that still correct?
I think that's still correct here. And there's actually a question that we'll get to later.
Okay,
that's one of the questions that the IRS puts in the form. How do you make your documents, financial statements, governing documents publicly available?
You can put them on a website, but I think if somebody walks up, you're still required to provide, I think.
Yeah. I mean, it's easier now because you could just click on the link on the website and pull it off and show it to somebody, but yes.
Yeah, you are required to provide it. Just remember, Schedule B of the 990, which Matt will get to later, is not open to public inspection. So that Schedule B, you do not have to provide. That's your list of donors. You don't want to give your donors out to people.
So again, the point here, the takeaway, expand, be a little bit verbose, try to drill down and figure out what your true social impact is of your programs instead of focusing on just plain dollars and cents, because that's not what gets dollars into your organization anymore. Skip a few more parts, we get to Part 7. This is one that is surprising to board members and executives of nonprofit, that their salaries and their benefits really become publicly available also once you're over a certain threshold or if you're in certain key positions. So Part 7 is the compensation of the officers, directors, trustees, key employees, highly compensated employees, independent contractors. So there's a lot of labels there. And what I want everyone to walk away from this presentation knowing is that the labels are not always the clearest, and the IRS is not known for being the clearest regulatory body, right? So the 990 has an instruction manual that goes with it. It's actually pretty helpful. It follows the format and the flow, really, of the 990, pretty much word for word and line by line. So in there, you would have definitions for each of these. Don't ask me now. I can't give them to you word for word, but we could provide you definitions. We have people in the crowd that have computers that could answer that. But, you know, what's an officer? What's a director? What's a trustee? What's a key employee? What's a highly compensated? It all sounds very similar, right? It's because it is. And sometimes it's difficult to draw lines between these different areas. But really, check the definitions there and just know that for key employees, if they earn over $150,000 in the last calendar year, they'd have to be reported here. Highly compensated employees and independent contractors, that number is $100,000. This number was actually increased by the IRS a few years back. It used to be lower. And a lot of you are probably fiscal year agencies with a June year end or an August year end or a March year end. You would still use the W-2s or the 1099s for the last completed calendar year for this. This guy's hiding compensation. He's leaving. He doesn't want to hear anymore about this. But that would be what gets reported there. There's some inconsistencies there. It's been difficult. Us as accountants and auditors always had a hard time, let's say you're an August year end, finding out exactly what that person earned for that, you know, September through August year, because it doesn't match up perfectly with payroll tax returns, this and that. So we're still seeing some errors here where organizations are trying to report on their fiscal year. You're not supposed to. You're supposed to use the last completed calendar year there. To talk a little bit more about this Part 7, this has become the most reviewed section of the 990, especially in New York State, where Governor Cuomo signed into effect, I think in 2013, Executive Order 38. So what Executive Order number 38 states is that it prevents public funds from being diverted to excessive compensation and unnecessary administrative costs. So what does that mean? Essentially, unless a waiver has been granted, a quote covered provider, which I can talk about a little bit here, is prohibited from using greater than $199,000 in state funds only to pay executives. So the state is now looking at the 990 because it has the information on how much people are making. Now, this isn't as scary as it sounds because organizations typically aren't 100% funded by certain state agencies. They have other funds from donations, contributions, other grants from outside sources that they can use to pay people over $199,000 if they so chose. But it's important with EO 38 that you have compensation studies in place, at least in a drawer somewhere. It shines a brighter light on executive compensation. A lot of organizations now have compensation committees that are looking at data from GuideStar, from Charity Navigator, from the State Charities Bureau website, and benchmarking themselves with similarly sized and similarly operating organizations to make sure that their executives are being paid fairly, not too much, and also not too little. So the takeaway here, make sure you're looking at executive compensation and you're treating it seriously because the rest of the world is. Make sure you're looking at Executive Order 38. If you've never heard of it before, we should talk after this. There's a great website that the state actually produces itself that really walks through what's considered a covered provider. Generally speaking, it's an organization that receives funds from a slew of certain state agencies. So it's like the Office of Mental Health, OPWDD, things like that. It's not every state agency, but it's a lot of them. And there's a disclosure form that you have to file every year with them stating that you're in compliance with their administrative cost screens and with the executive comp rules.
A quick question related to that. How often do you think you need to do a compensation study?
If you did it every year, you'd be covered.
So if I did every year, I wouldn't be able to give anybody any compensation because there's accounting firms out there that do this kind of work, and it can get a little costly. And I'm just wondering, is it 2 years, 3 years, something like that, and reasonable?
Yeah, I think what we're seeing in best practice form is that it's every 3 years that you at least have something in place. We're one of the accounting firms that does this. We've done several in the past couple of years. No, we're not that expensive. No.
We're actually really cheap.
We're actually really cheap. No one paid to come here, right? That's why the heat wasn't turned on, though. It also keeps everyone awake when you talk about, the shivering keeps, the blood flow. So yeah, every 3 years. 1 year is obviously best practice, but could you get away with 3 years? Probably, yeah. So the next several parts here, Part 8 through 12, this is where the accountants get exciting. There's less words and more numbers, the financial reporting aspect of things. So Part 8 is the statement of revenue, 9, expenses, 10, the balance sheet, 11 is the reconciliation of net assets, and 12 is the financial statements and reporting. We'll go through them here. Statement of revenue is really exactly what it appears to be. It breaks out and disaggregates your revenue between different categories. You have your contributions, your gifts, grants, program service revenue, events. It'll show the profitability on your events. If you sold assets during the year, it would show the net gain on that, the gross, less the direct costs, and any other revenue. It's worth noting here that donated service revenue is not included in the financial reporting section of the IRS. So I mentioned earlier how there's some differences between tax and accounting. There always is. Well, this is one of those differences. I think the main reason is if you're donating services or time, you as an individual will not get charitable contribution deduction on your own personal tax return, your Schedule A, your 1040. This is something that's surprising to people when I say it. And the real rationale there is, one, it's not necessarily costing you anything. Two, it's so easy to manipulate. If I'm an accountant and I'm donating my time and I'm volunteering, what is my hourly rate? I can say it's anywhere from $50 to $400 an hour. And the IRS doesn't allow that because it's just too subject to that overestimation there. So if you're eyeballing, if you're really shrewd and you're a detail-oriented person and you're comparing your 990 to your audit, if you get one, or your internal financial statements, they don't necessarily have to match, and this is one reason why. Part 9 is becoming very important. It's a statement of functional expenses. So this is really a grid work that shows how you're spending in different ways. First, it shows what you're spending on what we call natural classification. So what's the inherent type of the expense? Is it salaries? Is it rent? Is it supplies? Is it accounting fees? Is it legal fees? Is it God knows what else? So it shows that in one form, and then it aggregates those by function. So how much of each of those lines is spent on the program, on management in general or administration, and on fundraising. So this is very important because it builds up to a program service spend number, which really has become the hallmark benchmark for nonprofits. What percent of your budget or what percent of your expenses every year is going to your mission? I mentioned earlier the foundations associated with our two candidates in the past election cycle. One of the accusations was so much was going to administration and really not to the intended purpose of the organization. So the IRS grants organizations tax-exempt status thinking that they're going to spend it for that tax-exempt purpose, not for, yacht trips and God knows what else goes on out there. So people focus on this a lot too because they want to see how much is spent on the mission, on the programs, and it becomes very important that you really present this accurately. What we see in the audit world, in the financial statement world, is that not all nonprofits have to file a statement of functional expenses in their annual audits yet. They will starting in 2018 and 2019, depending on the type of fiscal year. And for really, I'd say 90% of our clients, we throw it in there anyway because we think it's really good information. So it may not be required, but it really is best practice now that you break out your expenses by function and by type. Because it's so important, we put another slide here about it. So there's different methods of allocating expenses. It's not very cut and dry. It becomes very muddy, especially, question.
So I have a combination of a question and a statement. In speaking about the yachts, and there was some previous conversation about the administrative cost and the directors. With a long history of being involved in non-for-profits, I think that just blanket statements can hurt non-for-profits because when you have someone who is worth a higher salary or you have a center of influence that can be involved in the yachts, they attract a much higher level donor base and they build relationships that can be far more valuable to the non-for-profits organization and to their goals and objectives. And oftentimes I hear people reading newspaper articles and just coming to the conclusion of, oh, they're getting paid too much. But there really has to be an evaluation on what's the return on investment that the non-for-profit is bringing into the fold because of those actions. Yes, there are those who abuse it and there are those who are not doing the right thing, but there are many organizations that are attracting major donors by being in the right circle of influence.
It's a fair point. I didn't mean to be flippant in that comment. It's worth noting that there is a supplemental schedule to the 990 that allows the organization to talk about if you're talking about executive comp privileges, one of them in there is things like that. More so what my focus here is that the overall program spend for the organization should be in an acceptable range. So if it's at, let's say, 50%, it's clearly too low. If it's spent on frivolous yacht excursions instead of productive ones, it's something that's concerning. But your point is very well taken.
Well, it's an important point. So the balance
Yep.
be there.
Yes,
It's just not a one-way street.
I agree. Okay, so going back to the next page here. So I started mentioning how it's not cut and dry how costs are presented between program administration and fundraising, especially for small organizations that have a small staff, that everybody does a bit of everything. So is the executive director 100% administration? Probably not. Probably should be some component for fundraising there. He or she probably gets heavily involved in programs too at certain sized organizations. So you need to carve up and allocate the time for people for everything else. People and salaries and related are usually, let's say, 2/3 to 3/4 of the budget. So that's the one we focus on most. So what systems are in place to make sure that those allocation methodologies are accurate and fair? We see time tracking systems. We see time studies. I know if you're funded by the state from certain agencies, you should be doing a quarterly time study, a couple of weeks every quarter for people that cross over different functions to make sure that you're presenting their costs in accordance with what reality is instead of just a blind estimate once a year. Square footage analyses we see for rent and other occupants related costs. Management in general should really be those costs that are not directly assignable to programs and not for fundraising. Fundraising costs should be those spent on raising funds. Obviously, that's kind of obvious to say there. Renewing grants, running events, things like that. Development people are fundraising. Some part of key executives typically goes to fundraising as well. Check this percentage. It's very important. Everybody looks at it. I know how the world is shifting from the financial metrics to this impact model. It's struggling a little bit in making that shift because impact is difficult to quantify. So a lot of people are resorting and going back to the age-old program service percentage. How many cents of every dollar is spent on the mission? So we used to do a survey, and now we just have data from dealing with so many clients. It really depends on the type of organization you are and your size, because I know the question is always, well, what should I be? What should I be at? And it's impossible really to answer that without knowing the true type of organization that you are and what goes on there. But I threw a number out there earlier at 50%. It just seems inherently low and it begs questions. We typically like to see the 70% and up. We have some organizations here that are in the 90% that we know are in the crowd. So that's phenomenal. And no one could ever question that. The point is, the higher the number it is, lacking any context, because people don't always have context when they're looking at numbers, a higher number is better, right? So if you're looking at your 990, if you're a board member and you're seeing that your program percent seems a little low based on what you know about the organization, you may not know the day-to-day, but you know enough about what they do. And if it may feel wrong, ask a question, because all too often we see that auditors and accountants are preparing these schedules. Management may not really understand what it is. The boards aren't day-to-day involved, so they're not really looking at it. And maybe the accountants are making false assumptions that could be challenged, should be challenged, and could result in a higher figure if you just ask a simple question. It's the whole railroad thing. If you see something, say something. We'll flip to Schedule A. There's a few pages on this that I'll try to boil down to speed this along. So I mentioned earlier how not all tax-exempt entities are charities or public charities. There's a designation. So 501c3s can typically be, and that's a charity, can typically either be a public charity or a private foundation. There's a third classification that really never comes into play. We won't talk about it. So public charities enjoy preferred deductibility for donations as opposed to private foundations. Thinking of a private foundation, think of like the Bill and Melinda Gates Foundation. It's heavily funded by a small group of individuals that don't necessarily get to deduct all the funds that they're giving to this organization because they're directing it. They do have certain spending requirements. They have to spend certain amounts of income every year and stuff like that. On the public charity side, though, it's pretty much fully deductible based on everyone's individual tax situation that's giving money to the organization. So you'd rather be a public charity if you had to choose, all things being equal. Obviously, private foundations exist for a very good reason as well. But to qualify as a public charity, you have to meet certain financial tests that appear on the Schedule A of the 990. So the two general tests are either the 33 1/3. The 1/3 test or the 10% facts and circumstances test. We'll go through them quickly here. So the 1/3 test is 1/3 or more of your total support must come from governmental agencies, contributions from the general public, not just a couple of people giving you all of your money, and contributions and grants from other public charities. It's based on a 5-year rolling average, so you can dip below and go above that 33 1/3 number and smooth that over time, and that's how the form, it's really a self-calculating form here, Schedule A of the 990, that presents a final number that's either above or below that 33 1/3 number. If it doesn't meet the 33 1/3 number, doesn't mean you're not a public charity automatically. You just have to go through another step. There's a 10% facts and circumstances test. So as long as that figure that it calculates is greater than 10%, and you can explain why it really operates as a public charity despite being below that 1/3 number, you still should be good and get that status. Schedule D, and I know we're skipping, I'll talk about later what these skipped schedules are. Ken mentioned earlier, Schedule B is the schedule of contributors. It shows major donors, how much they gave you during the year, and what their addresses are. So that's why that's not public information, because that really should have a degree of anonymity there. Schedule C, I think, is for lobbying. Schedule D, supplemental financial statements. It's a catch-all form that really supplements what's in the front. So when we're talking about revenue, expenses, assets, liabilities, it gives you more freedom to expand on what those numbers really are. It also presents any reconciling items that may exist between your internal accounting, your audit, and your 990, like the donated services I mentioned earlier. Another thing that doesn't come through on the 990 is unrealized holding gains on investments. That's not really counted as revenue in the 990, whereas it is in the accounting world, so that would show up here too. It also expands on information for endowments. So endowments is if you have some sort of permanent restriction or a board-designated fund that exists, it pretty much rolls forward the prior balance for the past, I think, 4 or 5 years, what the income was in the fund during the year, how much was spent, and what the beginning and ending balances were. Details on other assets or other liabilities. Anything that's considered other in the front part of the 990 gets explained in more detail here. So skipping a few more letters of the alphabet, we get to Schedule O. The IRS added Schedule O. I guess it stands for other. It's essentially a blank schedule. This is where if you want to really go into depth about your programs, about your mission, about what you do, or really about anything else, if there's something funky or unusual in the front of the 990 that you think any reader should know more about, you can throw an explanation back here in Schedule O. Related party affiliations. There's a question in the 990 about what's the board's process for reviewing the 990 before it becomes filed and publicly available. You can expand on that in here. There's a question in the 990 about what your do you have a conflict of interest policy? And if so, what is it? What do you do? This is where you can say, yes, we have a conflict of interest policy that is such and such. You can go into more details about executive comp, you know, how it's approved, how it takes place, what studies you may do from time to time, every 3 years, things like that. And there's questions about your governing documents and the financial statement availability, which is what was answered, which was asked and answered earlier. Another more overarching theme I want to talk about before I leave you today. So just because you're a nonprofit tax-exempt charity doesn't mean you don't necessarily ever have to pay income tax. If you perform an unrelated business, you may be subject to unrelated business income tax. UBIT is what we call it, the nice short acronym there. So what is unrelated business income, or UBI? It's income from a trade or business that is regularly carried on and that is not substantially related to the organization. It's charitable, educational, other purposes, things like that. So we have gift shops, rental income, you're selling t-shirts and things like that, that they're really not charitable in nature and they're not really connected with the mission aside from funding it. You know, funding something doesn't necessarily qualify it as an exempt purpose. If you have 1,000 or more of unrelated business income, you must file what's considered a 990T. It's a supplement that goes with the 990.
Just one comment. Matt mentioned, you know, rolled off a bunch of different things that may be subject to unrelated business income. Just understand that every rule has about 3 or 4 exceptions under this provision. So just be careful. So Matt mentioned rent, if it's debt financed, you know, so they're just take the time to go through the section to find out, because there's de minimis rules here and everything else. So just, you know, go through it, because every rule has a bunch of different exceptions.
Yeah, and what I would have said is the takeaway here is that, again, you're not involved in the day-to-day if you're a board member. but you know enough about what's going on. And if you hear of some idea that just doesn't sound like it's what the organization typically does, you should ask a question. You should ask someone like us, because we know or can look up all these different exclusions and exemptions. And there's a really good publication that the IRS has out there. It's publication 598. If you Google that, you'll get a PDF that's probably about 100 pages long, and it walks through specific examples. So chances are what you're confronting, the situation, the proposed new service area, whatever, is not new. There's nothing new under the sun, right? So this publication 598 really outlines a lot of these examples, exclusions, and what really you may be subject to. Be careful not to have too much unrelated business income. What is too much? Not really defined. Best practice has come into this 15 to 20% range. Obviously, if it's over 50, it's more than half of what you're doing, and that just is way too much and obvious. But is there a sweet spot and a good number? Practice has been saying that it's in that 15 to 20% range, where if you go over that, you may be jeopardizing your tax-exempt status by doing too much unrelated business or operations that really is not what your exempt purpose is. When the 990 was retooled several years ago, it brought in a whole slew of questions about oversight, governance. So there's increased transparency here. And all these questions, by the way, to tie back to what I first started talking about, these questions affect your Charity Navigator score, whether you're saying yes or no to these different things. So what's the annual review of your governance documents, your 990, executive management, that has to be included. Executive comp we talked about. Related party transactions have to be disclosed in Schedule R. If you have affiliated entities, you have to describe the nature of the transactions, how much was transacted, depending on dollar thresholds and things like that. Do you have a written conflict of interest policy? Do you have a whistleblower policy? Do you have a document retention and destruction policy? You may think, well, what business is it of the IRS and the public to ask these questions? But if you say no to these things, does it raise a red flag in anyone's eyes that may be supporting you otherwise? Just want to talk about some common mistakes that we see, because we prepare, like I said, over 200 990s a year, and we inherit clients that have 990s that sometimes we have to amend because they haven't been prepared correctly. Really, most importantly, get the thing filed on time. Even if it's 90% right, get it filed on time and go back and fix it later. The extension for organizations that are 12/31 year ends, the initial deadline is May 15th. It can be extended 6 months to November 15th. And for June 30th, it's really the converse of that. So June 30th year end entity, your 990 end state return is due 11/15. Otherwise, it gets pushed to 5/15 May of the following year in extension. So really, you have 10.5 months to file this. There's very few, I think, legitimate excuses for not filing on time. Failure to file for 3 consecutive years results in an automatic revocation of your tax-exempt status. The IRS doesn't even have to think about it. Their computers are just set up to spit out these letters and revoke your status. So we got a lot of clients a few years ago when this became a new process and procedure of the IRS, because so many organizations lost their status, didn't realize they were going to lose their status, and we had to try to fight for it and get it back for them. And there's a simplified process to get it back, but it is annoying. It's a pain in the neck, and you really incur some costs that you wouldn't want to have to otherwise incur. What's the legal name of your organization? We see that the right name isn't always used on the 990, believe it or not. IRS has your name based on what's on your 1023 application, and it tries to match up. So if you shorten your name, or if you abbreviate, or you use some other cute name that isn't really what you are legally, you may get a letter from the IRS, and no one wants to get a letter from the IRS ever. Filing an incomplete return is the same as not filing a return at all. So while I said before, if it's 90% right, make sure it's complete at least. If you have to change the numbers around and add some more details later, you can certainly do that. Late filing penalties can accrue up to $50,000 for not filing on time. Realistically, if you've been a good taxpayer or tax filer for the IRS for the 990, if you haven't filed late in the past, you can write a letter pleading for them to abate any penalties. They're usually pretty good about it, unless you've had a poor history in the past. And you have all the applicable schedules that you're supposed to have. You know, we talked about schedules A and B. C is for lobbying. D, G is for fundraising events. If you have any specific fundraising events, Schedule G outlines the performance of your top 2 events, and then it smushes together all the other ones. If you have contributions within and outside the United States, Schedules I and F may come into play. If you have significant non-cash donations, Schedule M. If you have related party transactions, Schedule R. For those related entities, we see a lot of times that there's a large parent organization, and then there's all sorts of little ancillary organizations that are also nonprofits, that are also tax exempt, but they have minimal operations. So one mistake we see is that all of the operations are reported on the one main umbrella entity. That's not right unless you have what's called a group exemption. We don't see a lot of group exemptions out there. What we also see is that parent company reports only its income and expense, and the other smaller entities don't file anything. It's also wrong. So make sure you understand your corporate structure, who really needs to file what, and file for every one of the entities that are involved in your operation. Improper allocation of expenses we spoke about that. Failure to report unrelated business income we see a lot of, and the failure to report lobbying activities on Schedule C. Does anybody have any questions before I turn this back to Ken Cerini?
So just a word of advice for the board members in the room. If you haven't seen the most recently filed 990 of your organization, when you leave here today, send an email and get it immediately. And if it's the first time you're looking at it, obviously that's a problem, especially because it's likely that when you look at the 990, you'll see that someone has checked the fact that it's been given to board members to review before it was filed. And then also kind of based on all the information that you got from that, do a reality check and make sure that it accurately reflects the activities of your organization and the governance of your organization, and be advised that the enforcement section of the Attorney General's office in New York has a sub-department that's dedicated just to reviewing 990s for red flags in terms of poor governance and other things that would cause the Attorney General to be reaching out to you to find out what's going on. So the 990 is incredibly important. It's not just donors that look at it, it's regulators like the Attorney General, and for sure, you guys, if you're board members, should be looking at every 990 before it's filed.
Thanks, David.
Thank you. I have a question regarding the unrelated business income. If a volunteer of an organization sells T-shirts, hats, that kind of stuff, and donates the proceeds to the organization, is that considered unrelated business income?
I'll grab this one.
I think there's an exclusion for volunteer-led activities.
There is. Yeah, there's an exclusion for volunteers. So if you have an unrelated activity that's performed exclusively by volunteers, it's not subject to UBIT. So they don't even have to do it separately and donate the money back. They could do it as part of the organization. And as long as it's done exclusively by volunteers, it's not subject to UBIT.
But did you mean to say that if the funds were used to fund the mission of the agency from the sale of such, that it's fine?
No. What I'm saying is there's a common misconception that all the money goes towards the charitable purpose of the organization. However it's raised or generated from whatever potentially unrelated business income that's generated, it's spent on the mission. So that automatically in people's heads may say, well, this is not subject to tax. I'm just saying, try to avoid that line of thinking because it doesn't necessarily work in all cases. But there's a lot online about unrelated business income. There are a lot of exclusions and exceptions out there, but there are certain aspects of businesses that are unrelated and people don't realize. Is that it? All right, thanks everybody.
All right, guys, we're on the home stretch here. I know everybody wants to get out of here. You can leave now if you want. I'm not going to stop you. All right, so I'm talking about apparently board governance issues and alerts. So let's see what I know about that. All right, so building an effective board. So one of the things I want to talk about, I mean, everybody goes out and the key thing everybody's focused on is how do I get board members? How do I build an effective board? And by the way, the presentation is in your folder. So you have a hard copy in your folder. So one of the things that I find is that when you hire an employee, you go through a formal process. You interview the individual, you have multiple interviews, you bring them back, especially a key employee like an executive director or a CFO or something. Yet when you add a new board member to your board, oftentimes one of your board members vouches for him. Hey, they're a good guy. bring them part of the club. They vouch for them, but that's it. There's really no formal interview process that takes place in a lot of instances. Some organizations have a nominating committee. They may, have that person go through the nominating committee, but then you bring them to the board and you're asking the board to kind of spend 5 minutes with them and vote on them. And to me, that just doesn't sound right. It sounds like there should be a more formalized vetting process that takes place. So if you're not going through a formal vetting process to bring your board members on, it's something I think you should think about. So let's kind of talk about what should be part of that vetting process to bring on a new board member. So one of the things that I'd be interested in is, why does the person want to be on the board? I mean, that's an important question, because if the person is looking to join the board because they're passionate about the organization, then they're probably likely to be a good, effective board member. If you're bringing someone on the board because they want to network with your other board members, probably not a good fit for your organization. So one of the things that I'd be interested in understanding is why they want to be on the board. Because if they're invested in the organization, is it something I said? Okay. If they're invested in the organization, it seems like this side of the room is clearing out, this side of the room is engaged. So I want all you guys on my board now. So if they're invested in the organization and invested in the mission of the organization, they're probably more likely to be effective board members. Can they effectively contribute to the board? Do they have the knowledge the organization needs? So when you go out and you look at your board and you look at the how your board is, the components of your board, what do you need on your board? Every board looks to have some sort of legal representation. Every board looks to have somebody who has a business background. Every board looks to have, maybe someone programmatically inclined who has, some knowledge about the program of the organization. So part of what you need to do also is look to see what are the components that you have on your board or that you need on your board, so that when you bring on a board member, they're going to be a good contributor to the board and add value to the relationship. Do they have the appropriate time? I think you need to be fair and upfront with potential new board members to let them know what the expectation is to becoming a board member, so they understand what the commitment that they're going to have to make. Because if they're not going to have the time to make that commitment, then they're not going to be an effective board member. So how often are you meeting? You want to let them know that. What other committees do you expect them to be in? How much time do you anticipate that they're going to be spending in their involvement as a board member? And that goes for committee members too. I mean, this doesn't just hold for board, it holds for committees too. So let them know, give them a fair, reasonable estimate. I've heard people say, well, if I tell them it's going to be, 10 hours a month, I'm going to chase them away. Well, if you don't tell them it's going to be 10 hours a month, they're not going to put the time and effort in, and you're not going to have an effective member anyway. Do they have appropriate financial resources? So think about it. Most boards, if they don't, should have a give or get component to being on the board. So you're looking to see that anybody that you're bringing onto the board understands, first of all, what the responsibility is from a give and get perspective. And they also then have the financial resources to either give the money themselves or to be able to contact other people that they know to get the money that's required of them to be a board member. Do they have political connections? For any organization that is funded by a governmental entity, political connections are extremely important. Organizations all the time go through audits. Organizations need to do some lobbying. They need to get rate changes, or there's modifications and regulations that come down the pike that need to be discussed. So if you've got a board member who's got strong political ties, or a potential board member that has strong political ties, I would vet that out as part of that process and find out how willing are they to utilize or reach out to those political ties to help your organization when it's needed. And that doesn't mean that at the drop of a hat you say, hey, can you call in? No, it's just as things are needed, that's when you do it. So those are things that I think are important. Are they going to be an active or passive board member? Are they just going to show up at board meetings, leave, come back a month or a quarter later, show up at another board meeting and then leave? Or are they going to be engaged in the organization in between meetings? Are they going to get involved in what's happening? Are they going to be really involved in the governance of the organization on a continuous basis? They should, I believe that before you bring a board member on, they should have some level of interaction with some of the other board members on a one-to-one basis. go out and have a cup of coffee, go out for breakfast or something, and just really get to know whether this person is going to be an effective board member, and let them get a real understanding and be able to ask questions about what really is the involvement, what do I need to do. Again, like I said, too often a board member is introduced by a member of management or another board member, and we just blanketly approve them without really going through a formal vetting process. How many of you have board contracts? Show of hands. 2. Okay. Well, it's a small crowd now because there were more people. All the people who left are the ones who had the board contracts. I'm a firm believer in board contracts. Okay. I believe that every organization should have a board contract. And let me kind of tell a little story about the Imagine Awards that we run. We have a committee. And for the first 4 years of running the Imagine Awards, I asked people to be on the committee. They said yes. They got involved in the committee, and some of them were effective, some of them were ineffective, some of them contributed and got, give or get, some of them didn't. This past year, last year's Imagine Awards, we actually put together a committee contract, and we laid out how many meetings they were required to show up for. We laid out what their commitment was in terms of bringing in contributions and bringing in sponsorships. We outlined their commitment in terms of reading through the applications and being there at the meeting. We had the most engaged committee that we've ever had, and we brought in more money than we've ever had because everybody understood what their responsibilities were up front. There was no, when someone agrees to be on your board of directors, what's the contract? You ask them, they say yes. It's kind of verbal. If I give you a piece of paper, you read through the piece of paper and you sign your name to it, there's a much deeper involvement because you've committed and you've documented that commitment. So if you don't have a board contract, it's something that I think you should think about implementing. So again, what should be outlined in that contract? The number of meetings you have each year and how many meetings are you responsible for attending? Are you involved or required to be involved in any committees? So what committees are, how many committees are you required to be involved in? Do you have events? Are they required to participate in events, and how often? How much time will the role realistically take? If it's a 10-hour-a-month role, that should be listed in the contract so that they understand that they're making a commitment to spend 10 hours a month. What monetary commitment is expected? What's the give and get? All of that should be laid out. One of the things you need to understand is that, and David, you could kind of vouch for this, but under the Nonprofit Revitalization Act, you can't just turn around and kick out a board member without having a valid reason for getting rid of that board member. The board contracts helps to create that substantiation for showing that a board member is not meeting their obligations and not meeting their commitment, because you've now got a contract that they've signed, and if they're not showing up for the meetings, they're not doing the give or get, you don't have to wait for their term to expire. You actually have something that you can point at and say, you're not an effective board member, you're not doing what you committed to do, and therefore we're going to take you off the board or ask you to leave. What role do you expect the board member to play within the organization? That should be laid out in the contract too. I was involved years ago. I was the treasurer of the Suffolk County Make-A-Wish Foundation. And the board went out and they were looking for a lawyer, and they found a lawyer and they brought the lawyer onto the board. And then one board meeting, they started asking him legal questions. He goes, no, I'm not on this board because I want to be a lawyer. I'm on this board because I want to grant wishes. So I don't really want anything to do with the legal aspects of this. I want to get involved in the programmatic aspects and grant wishes. That's really what I'm here for. So it's important for you to understand that if you're bringing on a board member and you have a role that you expect that board member to play, that's spelled out in the contract too, because that may not be the role that they want to be playing within the organization, and you want to make sure that your thought process and their thought process aligned. And that's where, again, I think the board contract becomes important. But a contract is a two-way document. So remember that. So you're asking them to make certain commitments to you. On the other hand, you have to make certain commitments to them as board members. So things like D&O coverage, I would outline within the contract that there's D&O coverage and what that D&O coverage is. I would also outline how many of you provide indemnification for your board members. So a few of you. So if I'm on a board, okay, yes, there's D&O coverage, but what happens if the D&O coverage is not, the board does something or something happens, and David has seen many cases where, something happens and the D&O policy says, I'm not paying. We have one right now with a client of ours where they were interviewing a potential executive director. The interim executive director sent an email to him, says, welcome aboard. The individual was never hired, and he sued the organization for several $1 million, and the D&O policy said, we're not paying. So, we're in a situation where now if they went against, and there were other factors too, but if they went after one of the board members and stuff personally, the board member could be liable because there's no D&O coverage. So one of the things that we suggest is always that you have an indemnification clause, and you can put that right in this contract that basically says that if the D&O coverage doesn't kick in, then we'll indemnify you as long as you were doing your job and you followed your duties that you were outlined to provide. A couple other things on the board contract. So again, what are the other management commitments? So part of what you want to do is you want to provide timely financial information. You have board members who are supposed to be governing the organization and are supposed to be out there providing information or looking at information and making decisions based on that information. They're only getting that information the day of the meeting or 10 minutes before the meeting starts or at the meeting. How can they actually go through and vet that information, be able to ask intelligent questions? So you want to make sure that as part of your commitment to them is that you're going to get them information on a timely basis so they can do their job. If they have questions, within reason, you should be able to ensure that they have someone that they can go to and get responses. And again, provide the necessary information and appropriate support to allow for the decision making. Remember, they're responsible for the governance of the organization. Matt, question? Right in front. Sorry, we just need to make sure the microphone's there so they can pick it up on the webinar.
To go back to the indemnification, is that a separate policy or is that out of somebody's pocket?
That's out of the organization's pocket. So that's going to be the organization is indemnifying the board members. And David, I don't know if you have any comments you want to make on that as the attorney in the room.
Really, it's part of the contract between the organization and the board, and so very often it's in the bylaws. Sometimes it's even in the certificate of incorporation, and it's just as Ken said, it's a commitment from the organization, assuming that you as a director, and there's some limits in the law on how far indemnification can go, but the basic concept is assuming you as a director haven't done anything improper, the organization is going to stand behind you if you're liable, and they'll also pay for the cost of your defense. So it's really a contract between the organization and you as a director.
And remember, it's tough these days to find really effective board members, so you want to make sure that you level the playing field, or at least you're at the top end of that playing field. So you need to be doing things like making sure they have D&O coverage, making sure there are indemnification clauses and stuff like that. But as I said before, I'm a firm believer in board contracts, something that, again, if you're not doing right now, you should. Hello? Yeah, this is for that. I didn't touch anything. Again, building an effective board. New member orientation. Again, one of the things that we see a lot is that you bring on a new board member and you just throw them right into the fire. What sort of orientation process do you go through with your board members to ensure that the board members have a keen understanding of what's happening within the organization? Because if it takes them 6 months to get up to speed, and you're asking them to make decisions during that 6-month period, what level of decisions are they really making? So the things that you want to provide to your board is you want to give them the latest financial statements in 990, as Matt talked about, so that they can see a copy of the financial statements and the 990 and gain an understanding of the financial strength of the organization. And again, within the 990, they'll pick up some aspects of governance. You want to give them, every organization should have a budget. So you want to give them the budget and ensure that they're getting budget to actual reporting over the course of the year so that they've got good information to understand fiscally how the organization is doing and is the organization staying true to the map that's been outlined within the budget. If there's a strategic plan, you want to give them a copy of that business plan or strategic plan so they understand what goals the organization has on a long-term basis and can understand what the organization is doing and the direction the organization is moving in. Give them a tour of the facility. Let them see what the facility is all about. Have them talk to some of the program people so they can, and actually meet some of the consumers if it's an organization that works with individuals, consumers, because you want them to get connected to that organization. So you want to make sure that that's taking place. Give them copies of the board of directors minutes for the last 12 to 18 months. Let them understand what the organization has been talking about at the board meetings so that they've got some context when stuff comes up in meetings. Because what happens invariably is, they come to their first meeting and you're talking about a lawsuit that's going on and they have no context, they have no idea what this lawsuit is, and now everybody's stopping and trying to explain what's going on. If you give them some, the back minutes and they can read through those back minutes, they come into the meeting with an understanding of what's been discussed at the board minutes for the last, 12 to 18 months. Make sure they have certain governance documents. They should have the bylaws. They should have the certificate of incorporation. They should understand what the mission statement is. We tell all of our clients and all their boards, take your mission statement, tape it onto something that you're going to carry into that meeting with you so that you understand when you're sitting in that room, before you start the meeting, read that mission statement. That's why you're in the room. That should be the major focus of what your decision-making process is built off of, is built off of that mission statement. That's why you're there. And then make sure that they understand what the organizational structure of the organization is. You have some really, really complex organizations out there that have multiple entities. You have for-profits that are owned because of tax credits and everything else. Give them an understanding of what that organizational structure is so that, when decision-making process takes place, they really understand, what's happening within that organizational structure. Discuss with them the key issues facing the organization. So again, if there are lawsuits and stuff that are happening, or if there's an audit taking place, or changes in regulations that the organization is lobbying about and everything else, get them up to speed. Give them all that information, because again, you're asking them to guide and provide direction for the organization. And they can't do that if one hand's tied behind their back and they really have no idea of what's happening within the organization. Talk to them about trends in the industry. Let them know what's happening in the industry. It's important that they understand the challenges that the organization is facing and where the potential risks lie within the organization, and be transparent. I've been involved with many nonprofit organizations. Some of them, the board's really the people that are out there making the decision. In some organizations, you have a strong leadership, and management is really doing a lot of the legwork, and the board really is more of a passive role. One of the things you want to make sure of is, if I'm going to bring on a really strong board member and I've got really strong management, there's going to be some level of clashing that takes place there. So again, just make sure that as you go through this, you also understand the nature of the players within the mix and how those players kind of play together, and make sure that all of that's kind of explained to the new board member coming on too, because if they're going to be involved in a situation where management is going to be really headstrong in terms of how they do things, and the board isn't going to be, doesn't have that same level of oversight as it has in others, which shouldn't be the case, but happens quite often, they need to understand that so that there's not an issue. The more informed they are, the more of a resource they're going to be to the organization. So David talked a little bit about the board committees. So I'm going to kind of touch on this a little bit less than I was going to. But there are two types of committees, as David mentioned. There's the committee of the board and the committee of the organization. So I laid out a little chart here about the committee of the board and the committee of the organization. So the committee of the board is the ability to take action on behalf of the board, can only be made up of board members, must have at least 3, as David mentioned, and is really an extension of the board. And a committee of the organization cannot take action on behalf of the board. And again, the committee of the board can take action, but that all has to be laid out in the charter for that committee. A committee of the organization can have outside members, and it's supportive of the board. It's not an extension of the board. So that's kind of a Reader's Digest version of that. Committee should be outlined in the organizational bylaws. And again, in certain instances, charters for the committee should be outlined. They report to the board. They have no power to bind the board unless expressly stated, as David mentioned, and that would only be a committee of the board that can do that. And all committees should maintain documentation of minutes. So, you want to make sure that every committee is creating minutes, and you want to make sure that those minutes are getting to the board. Because if the committees are there to provide insight and vet issues for the board, then you want to make sure that board has that information before it meets, so it can review through that information so that when it has to make decisions, it makes the decisions with the expertise that was afforded by the committees. So let's talk about what some of those committees are. Can everybody read that? Because I can, and I'm standing right here. But it's on your page. So finance. So a lot of organizations will have a finance committee. And some of these are interchangeable. Some of them get collapsed into one committee. So I'm going to break them all out separately, but in some instances there's overlap and collapsing that takes place. But the finance committee is responsible to oversee the financial performance and reporting of the organization. Basically, it reviews and recommends annual proposed budgets. That's where the budget process goes through, budget modifications. It looks at establishing financial and accounting policies. It monitors financial performance of the organization. So that's where you're looking at trends and benchmarking and everything else. It's usually involved in your investments and tax filings and stuff like that. Audit committee, as I said, sometimes that's combined into the finance committee. That ensures that, understand that the board is responsible for setting policy. Management is responsible for ensuring that that policy is implemented. And then it's the board's responsibility to monitor what management is doing to ensure that the policy implementation is effective. So that's really what the audit committee's role is to look at the internal control environment and audit functions and make sure that those are in place and properly functioning. So it's the role of the audit committee to engage the external auditors, and if the organization has internal auditors, they're responsible for overseeing the audit process, monitoring the control environment, and making sure that there's effective internal controls in place. Compliance committee, also sometimes combined with the audit committee. Organizations that receive government funding often have certain compliance matters that they have to deal with. So if you get Medicaid funding, if you have over $500,000 worth of Medicaid funding, you're required to have a Medicaid compliance officer in place and everything else. We'll talk a little bit more about that later. So what you typically find is the compliance committee is really responsible for ensuring that this oversight is in place, meeting with the compliance officers, meeting with some of the program people to ensure that compliance is being met, and that's really the purpose of this committee. Compensation, Matt mentioned this when he was going through the 990. It's good to have a compensation committee to go through and make sure that the compensation recommendations for executive staff is appropriate. A couple other committees. Nominating committee. This is really the committee whose role it is to go out there and find more board members. So the nominating committee, is out there to develop a succession plan for the board of directors, and they seek candidates and recommendations to fill. Again, this is where a lot of that first couple slides, going through that vetting process, a lot of it can happen here at the nominating committee. Executive committee, David mentioned the executive committee. Some organizations have an executive committee that meets in between board meetings, and the executive committee can actually set policy and can actually pass resolutions on behalf of the board. So it's really important, again, to make sure that those types of things are in place. And then development committee, there's program committees, there's a bunch of other committees you can have. I like organizations that do a lot of fundraising stuff to have a development committee. And the reason is I've been on boards where they're talking about the color of the linens that's going to be at the fundraising event at the board meeting. That's not why I got onto a board. That's stuff that should be pushed off to a development committee or some other place where it's more appropriate. The decisions can come up and we can talk about big issues at the board. Let's not get bogged down 20 minutes talking about turquoise or whatever color this is. What? What was that? Barney purple? So, question. Matt, do you have the microphone? Well, I just want to make sure it's picked up on the webinar. Sorry.
Ken, you just mentioned the executive committee can set policy. Can you speak for a moment about what the executive committee can do and cannot do relative to what the board who sets policy also? So it seems like they both can do the same.
It depends on the authority that the board gives to the executive committee. If the board gives the power to the executive committee, then the executive committee can set policy, and if the board does not give the executive committee that power, then it can't. Typically, though, what I've seen, and David, you could tell me if you've seen something different, but I've seen that if there is an executive committee in place, it's usually the board has given that executive committee a certain level of autonomy to create and develop policy, because the executive committee is maybe a little more, it's usually made up of your board president, your board vice president, your treasurer, secretary, key members of the board who are much more engaged in the organization than the other board members. I've seen it happen a lot with national boards, where you have a national board and they're not meeting as often, but there's things that still have to be resolved in between meetings, and that's where the executive committee comes into play.
Thank you. Specific to that, if a sensitive issue comes to, say, the executive director, and the executive director says, I'm going to tell the executive committee about this, is there a responsibility for the executive committee to tell the rest of the board that issue, or can they keep it amongst themselves because they don't want it to get out?
Again, it depends on what the charter for the executive committee says. I'm on a board of directors where there is an executive committee, and I'm actually part of that executive committee. And when we get to really high-end issues, we do involve the board, because we feel that it's unfair to have a board where we're kind of circumventing the board and not allowing the board to be part of that governance process. So we do. David, you want to? Sorry to include you in everything, David, but
Oh, good. No, I'm happy. That's why I'm here.
That's why there's a lawyer in the room.
Right, there you go. So a couple of things. The executive committee and all committees are really operating based on delegated authority from the board. So based on that, and kind of remember what we said earlier, as a director, you've got these legal duties to the organization. So at the end of the day, everyone is responsible. So that goes to Ken's point that you really do have to report back to the board, because you, as an executive committee, or any committee, but the executive committee has the broadest authority, you're really just operating with authority that's been delegated to the board. It's ultimately the board's authority, so you do need to report back to them. And then in terms of your question about how much can be delegated, there are a series of things in the statute. I think there may be 7 or 8 items that cannot be delegated. So for instance, you can't give the executive committee the authority to amend your bylaws, or amend your certificate of incorporation, or approve a dissolution of the corporation, or a sale of substantially all of your assets. So there's a bunch of things that are so fundamental and so significant that only the whole board can do. And then one other footnote to Ken's great summary of committees. The one thing to keep in mind is that, and I think I alluded to it very briefly in my presentation, the audit committee is particularly sensitive, and the New York statute has a whole section just on audit oversight, and it really lays out a checklist of what the audit committee is required to do. And the other piece of that is the audit committee can only have independent directors on it, and if you've got one director who's not independent, based on the complicated definition in the statute, it invalidates everything that the audit committee has done, and is therefore a breach of duty, not just by the whole audit committee, but by the whole board. Because again, the audit committee is only acting based on delegated authority from the board. So those are really important to keep in mind.
A couple of things I want to touch on before we wrap up today. Some of the things that we see out there a lot is we see organizations who have investments but don't have investment policies. And we also see organizations that have endowments, which is, a lot of the investments fall into that endowment. And again, there's a provision out there that's known as NIPMIFA, the New York Prudent Management of Investors Fund Act. It's a New York State regulation that provides certain criteria that you need to consider when you're an organization that has investments, and even if those investments are held in cash. So what are they? You have to give primary consideration to the donor intent. So if a donor made a gift, you have to make sure the intent of the donor is followed. And that, so the NIFA rules cover both investments and cover endowments. So understand it covers both. So you have to give consideration to the donor intent. You have to act in good faith with care an ordinary prudent person would exercise. You need to incur only reasonable costs in investing. So you need to look at the fees that are being charged and make sure that those fees are reasonable. You need to make a reasonable effort to verify relevant facts. So again, if something's not clear within the donor letter, you need to make a reasonable effort to make sure that you clear up some of that. So if you're not sure whether something's restricted or unrestricted, or what the donor's intent was, you got to go and clear that up. Make decisions about each asset in the context of the portfolio of investment as part of an overall investment strategy. So you actually have to create an investment strategy and understand what that investment strategy is. And you have to, when you think about an investment strategy, you need to take into consideration a bunch of factors. When is the money going to be needed? What's the time horizon? What's the risk factor within the organization? How is the money going to be used? So all of those factors come into play. You need to diversify your investments unless due to special circumstances, the purposes of the funds are better served without diversification. So one of the things you have to keep in mind is, even if the money is maintained in cash, okay, you still need to follow NIFA, and the board has to ratify each year that they reviewed their investment strategy and the investment strategy is appropriate. So if your investment strategy is we're going to keep everything liquid, that's fine, but then you have to document why that's fine. And then the board needs to, discuss it and it has to be ratified. Because if we have some clients that are sitting on, let's say, $5 million and it's all sitting in cash. Well, when you look at it, it's 2 years worth of operations. Do you really need to have 2 years worth of operations sitting in cash? Is that really a prudent use of those funds, or should you be taking some of those funds and investing them to get a better yield or better return? So you have to then justify why you're not investing those funds and why those funds are staying in cash. You're required.
I'm sorry.
Sorry, go ahead.
A quick question. I think it's quick. I was led to believe.
Three.
Okay.
That was my answer. Sorry.
We've known each other too long. A quick question related to the Audit Committee and the Finance Committee. I was led to believe that there should be a split between those two committees, that they should not necessarily function together, and that members of the senior management team should not be in attendance at the Audit Committee meetings. Do you have any sense of any of that?
So I'll answer those, maybe not in the order that you laid them out. So members of senior management at the Audit Committee. I don't have an issue with senior management being at the Audit Committee as long as there's a period of time at that meeting where senior management excuses themselves and leaves the room, so there could be open communication between the auditors and senior management. Sometimes it's good to have senior management in that room to clear up issues that may come up, because a lot of times what happens is you're talking about an issue with the auditors, and then the question may come up, well, what's going on now with that, or what's the status of it, and the auditors may not have that information. So I don't have an issue with senior management being in the room as long as there's a period of time where senior management leaves the room and there's open communication between the auditors and the Audit Committee. In terms of whether there should be a split, ideally, yes, there should be a split between the Audit Committee and the Finance Committee. In practice, we see a lot of instances where you just can't find enough individuals to create two separate committees. Sometimes the board functions as the Audit Committee. So it really comes down at times to practicality. But ideally, yes, there should be two separate committees. Okay, so any questions about the investment policy? All right, so if we move on. Corporate compliance, we talked a little bit about that. And I mentioned before that if you get over $500,000 worth of Medicaid funding, you're required to certify each year that you're doing certain things. How many of you have over $500,000 worth of Medicaid funding? So a few of you. Do you know about the certification, know what the rules are and everything else? Yeah, okay, so for those rest of you, I'm not going to bore you. If the ones that do have Medicaid funding want to talk to me afterwards, I'll talk to them about it. But just understand that, what I find often is that there's not enough communication between the compliance people within the organization and the board of directors. And when you're dealing with compliance, and compliance can result in takebacks of funds upon audit, you really want to have that level of communication so the board understands what its risk and exposure is. And the board can understand that the compliance people are doing what the board believes the compliance people are doing. Pension, how many of you have pension plans? A couple of you? How many of you have your pension plan auditors or your investment folks coming to meetings of the board to discuss the results of the pension plan audit or to discuss the results of the investments for the year? Well, if you think about it, there are certain requirements on the pension plan side to benchmark the plan. So you're required to benchmark and look to see that the expenditure levels are appropriate expenditure levels. You're required to look at the investments on a regular basis to determine if the investments are effective. And if they're not effective, you're required to remove them from the portfolio and replace them with other investments. How many of you know that nonprofits have been getting sued by their employees because their pension plans are not operating effectively? So nonprofits are getting sued. Right now, it's been just universities. I think that's going to trickle down to hospitals and everything else. There's probably about 6 or 7 law firms that specialize in this. It's been happening in the for-profit world for a few years, and it's now, as of last year, dipped into the nonprofit world, and nonprofits are getting sued. One organization was suing, the employees were suing because one of the factors that they were suing on was there were too many options in their pension plan, and they couldn't make decisions because they were paralyzed because there were too many options.
Can't the finance committee take care of that responsibility?
That stuff the question was, can the finance committee take care of that responsibility? That's stuff that can happen at the finance committee, but again, it has to get reported back to the board of directors. And it's important for the board of directors to understand what's happening with respect to this, because again, DOL, the Department of Labor, is really going after not just nonprofits, but all pension plans. And you really have to make sure that you understand that your plans are in compliance. We've seen a couple organizations get hit up with pretty steep penalties because their plan got selected for audit. And if you're not doing everything 100% accurately, you're going to have problems.
There are a couple of real major issues that they're looking at. One is the number of options. There can be too many or can be too few. Can be training that's offered by you or others to the employees as it relates to those types of things. So I think there's a lot of stuff out there that we must really follow and look at very carefully.
Yeah, everybody thinks that they put into place the pension plan as a benefit to the employees, which is great, but then with it comes a fiduciary responsibility. So as you said, yes, you do have to pay attention to how you're educating your staff regarding the investment alternatives, whether there's appropriate investments within the plan, appropriate number and appropriate type, the costs, how are people getting into the plan. I'm a firm believer in that you should have an automatic enrollment within your plan so that when someone becomes eligible, they automatically get enrolled in the plan. And it's up to them to opt out of the plan as opposed to opting in. This way, nobody can say, hey, you never told me about the plan or you never invited me into the plan. If you have an automatic opt-in, that's great. And also, I'm also a firm believer in those age target plans or age target investments within the plan that provide for, instead of money going automatically into a money market account, which has low yields, if you put it into an age-appropriate fund that's based upon their projected retirement age, it's a lot safer. I know I'm running out of time. A couple other things. Communication with the auditors. I just want to make sure I stress the whole aspect of communication with the auditors because this is something that kind of David mentioned before. It's often that we go in and we make presentations to the audit committee or the board of directors, and we walk in and we're told, all right, you got 10 minutes. And we're supposed to tell them everything that happened over the course of the year and provide a lot of financial information in a period of 10 minutes. The reality of the situation is you really want to be able to spend the time with the auditors and gain some real insight into what's behind the numbers, and not just, look, here's a balance sheet or a statement of financial position and here's a statement of activities. What is the story that it's telling you? How do I compare to other organizations? What do the trends look like? Am I effective? Am I not effective? What are the key issues that we're running into as an organization? On top of that, the Nonprofit Revitalization Act doesn't just call for the meeting after the audit is over, but it also requires for organizations that generate over $1 million worth of revenue to have a pre-audit meeting too. So you're required to have both a pre-audit and a post-audit meeting. So if your organization is not having a pre-audit meeting now, you should make sure that gets implemented. We talked about internal controls a little bit. And again, we often see that we often see that key policies are missing, control environments not documented, how organizations are allocating costs are not laid out effectively, overall lack of segregation of duties that exist within an organization. And not every organization can have a perfect environment of segregation of duties. Understand there are two types of controls. There's prevent controls and detect controls. Segregation of duties are great, but they're more expensive and they require more staff. So if you're a smaller organization and you can't do that, put in place some oversight controls. So instead of maybe separating the HR and payroll function, which is really the best thing to do, if you can't, then at least have somebody whose job it is as part of each payroll process to review the payroll and make sure that all the people that are listed there are people who actually work for the organization, their salaries make sense, and that the number of hours they work makes sense. So at least have some sort of compensating controls. So before we get out of here, I just want to kind of make a couple little comments. First of all, there's an evaluation form in the folder. Please fill out the evaluation form. It's our way of knowing whether we did this right or not. If there are things that you feel we could do better, please let us know so we can incorporate that into future presentations. If there's ideas that you have on topics that you'd like us to cover in presentations, please let us know. If you'd like to get on our mailing list of newsletters and stuff like that, also let us know about that. We're actually going to be taping today's presentation, and as of December 1st, it should be available. So if you have any other board members who weren't able to make it here today and you want to share this presentation with them because you feel that they should suffer the same way you did, feel free to push it off to them and let them see it. And I do want to wish everybody a happy Thanksgiving.